Phoenix Ikner, who is the man accused of committing a mass shooting on FSU's campus last month during April, appeared in court via Zoom this morning. So we want to go ahead and break down exactly what happened in court this morning. So here's the deal. The judge actually denied Ikner's bond and ruled that he cannot contact the victims, the witnesses, or their families during this process. Eichner, just to catch you up to speed here, is charged with 2 counts of first-degree murder and 7 counts of attempted murder for the people who were involved in that mass shooting again last month on FSU's campus. Now, this morning, Fox 35 spoke with criminal defense attorney Jose Rivas to kind of break down where the case is against Phoenix Ikner, where it goes from here, and then also what the state will have to prove in court in order to get a conviction. Again, to remind you, he is a defense attorney who is not related to this case at all.
Right. So within and then the judge is going to read out the charges, the maximum penalty. It's going to determine whether he has private counsel. They're going to assign a public defender, and it's also going to establish any kind of conditions, what we call pre-trial conditions. Number one, is he entitled to a bond? If no, or if he is, either want to establish an amount of bond, and then he will establish any other conditions, including no contact with any victims, any kind of law enforcement. It's just, we want to set the parameters between now and the day of trial and set the conditions to make sure he doesn't violate them. It's not an adversarial hearing. In other words, we're not. Most judges would not entertain any kind of bond hearing, any kind of argument. Usually, that needs to be set for a specific hearing.
Okay, so now I don't know if you heard me earlier, but I have my colleague Marley Capper joining me here this morning. Let's go over some of these charges here because he's facing some pretty serious charges and several counts of them as well.
Right. So, the first degree murder, those charges, those are usually what we call PBL, punishable by life. They have mandatory minimums. Depending on some of the states, they carry a 25-year mandatory minimum. Those are day for day, no gain time whatsoever. So it's just a reading of the charges, exposure, and the judge will determine whether he has an attorney or not. So it depends. Again, it's a very early in the stage of the game. There could be a plea deal. Most of these cases, the offer, it's not a very good offer, most likely life sentence. So there's really no incentive for a defendant sometimes to take any kind of plea negotiation.
And for a case like this involving the seriousness of these charges, how quickly can we expect to see, court proceedings happen?
Well, typically the court set hearings get set every 4 or 6 weeks. By law, the state has 175 days to bring you to trial. The reality is that cases like this are very complex. They never go to trial within that time frame. Usually, it's going to get continued by the defense, so they can prepare a defense, and so they have to what we call waive speedy trial. They will have to continue the trial. In other words, it could take at least a year, 2 years before this case goes to trial. Why? Because you have to establish, number one, a defense. Number two, if there's any kind of mitigation. We can see, we're seeing already comments, some of his perhaps in mental health, he was on a medication. Those are all things that are going to have to be explored by the defense, by hiring witnesses, forensics. So there's a lot of work that's going to have to be done here to try to get the best possible result.
So that was actually my next question. Because there has been reports of him suffering from mental illness, maybe some mental disabilities, what is the end goal going to be at? I know you mentioned that if they're going to have life, that they wouldn't necessarily go through a plea deal process, but what can we expect for an end goal, especially through today?
Well, it's too early. When we talk about mental health, we're talking about two different things. Number one, is he competent to stand trial? You can be on medication for ADHD and still be competent to stand trial. So if there's any indication that he's not competent, it will be evaluation by the state, by defense, and possibly a third party. And then the judge will determine whether he's competent to stand trial. If he's competent to stand trial, the procedure continues. If he's not, then the question becomes, can we rehabilitate him? Could we send him over to an institution, secured institution? Is it going to take a year, 2 year? Can we rehabilitate him to the point where he can become competent? It's too early in the game right now to determine if that's a defense or the route that the defense is going to take.
Gotcha. And another question for you as a defense attorney, tell me this. When it comes to representing someone like Phoenix Ikner, what is the strategy here with all of the evidence that we've seen thus far with regards to there being video, with there being pictures, with all of the information that we know with regards to him being related to county deputy there? What is what's the strategy that you have as a defense attorney when representing someone like this?
Well, the reality is that sometimes the truth does not matter. I always say this, and
Mhm.
the reason I say it is because what matters is what is admissible in court. For example, there could be evidence that was illegally obtained that's not admissible. We can see it on the news, we can see it everywhere, but the jury would never hear it. And so, we have to keep in mind as defense attorneys, he's presumed innocent until proven guilty. Therefore, it's the government or the state's job to prove beyond a reasonable doubt, which is a very high standard, that he committed every element of the crime. So we keep the Constitution, we keep law enforcement, the government in check to make sure that procedures, the evidence is not contaminated, the evidence is not obtained illegally. So therefore, it's part of the process for us to filter in all the information and get the most, best possible result for our clients.
And how difficult of a case is this, or how difficult of a person would this be to represent with someone, speaking as someone with your expertise and your experience?
Well, again, the difficult part of a case like this is the exposure. Obviously, he's looking at the rest of his life in
Mm.
prison. The reality is that there's a lot of work that could be done. When we talk about either a defense, whether the state cannot prove it beyond a reasonable doubt, once we pass that threshold, then we go into what we call mitigation stage. The mitigation, yes, it occurred, but it occurred because of this reason, and therefore, a jury or the court should have this kind of mercy, not sentence him to life, sentence him to X amount. So it's a two-part stage. But the reality is, as a defense attorneys, we have to fight all the way till the end. The last thing that we want is just give in or tell a client to take a deal or admit to some kind of evidence that something is going to get appealed. The reality is that a lot of these cases, if not all of them, get appealed when someone is sentenced, and appeals take years. So we have an ethical duty to fight for our clients and use our profession to the best of our abilities.
I'd love to go back really quickly to the mental health aspect side of things. We know there's reports of his biological mother being charged of kidnapping him and actually bringing him to another county when he was younger. When you guys are looking at whether somebody can stand trial, how far back into somebody's history do you really look back to kind of make that determination?
We can always look at all the history, but the reality is, like I tell my clients, I'm not a psychiatrist, I'm not a counselor. So that's the reason we hire experts. Experts are going to come in and they're going to testify what effect that particular incident in his life had on this particular incident. So we have to connect the dots. The simple fact that something occurred in the past doesn't mean that has any kind of relevance to why this occurred. And again, we talk about mitigation. So, I mean, we could take a whole picture. There's circumstantial evidence, perhaps that the jury can put the dots together and have some kind of sympathy for the defendant, but at the same time, it takes an expert, a qualified expert in the courtroom to be able to testify as to how this came into play.